Generally, in corporate mergers and acquisitions, corporate management and majority shareholders owe minority shareholders a duty of entire fairness in the transaction. However, in some short-form mergers, which are mergers between a parent corporation and subsidiary, the merger is instead subject to review under the business judgment standard. In In-Re CNX Gas Corporation Shareholders Litigation, the Delaware Chancery Court considered whether, in a short-form freeze-out merger, the entire fairness standard applies. CONSOL Energy is a publicly traded Delaware corporation and the largest producer of high BTU bituminous coal in the United States. In June of 2005, CONSOL formed CNX Gas Corporation to conduct CONSOL's natural gas operations. CNX then made a public offering of stock, with CONSOL retaining most of CNX's shares. The remaining shares were owned mostly by institutional investors. In January of 2008, CONSOL proposed to acquire the outstanding shares of CNX through an exchange offer. However, CNX's largest minority shareholder, T. Rowe Price Associates, reacted negatively to the offer and stated they wouldn't tender their shares. 1 year later, CONSOL revamped CNX's corporate structure by eliminating CNX's board committees and decreasing the number of its directors. Following the revamp, John Pipsky was the only director on CNX's board that was independent. CONSOL then approached Price about acquiring its CNX's shares and later reached a tender agreement. CONSOL then issued a press release announcing the agreement. After announcing the agreement, CONSOL commenced a tender offer to acquire the outstanding shares of CNX. CNX formed a special committee, which included Pipsky, to evaluate the offer. However, the board refused to add an additional director or authorize the committee to negotiate. Nevertheless, Pipsky tried to get CONSOL to up its price, but CONSOL refused. The committee didn't give an opinion on the offer, but suggested that CONSOL's agreement with Price ensured the tender offer's success. Following the announcement of the tender offer, CNX's shares didn't trade for more than a couple pennies above the tender offer price. Subsequently, minority shareholders sued CONSOL and CNX in Delaware Chancery Court, seeking a preliminary injunction of the merger. The shareholders argued that the transaction should be reviewed for entire fairness. In particular, they claimed the transaction wasn't entirely fair because, by entering into the agreement with Price and announcing the tender offer afterward, CONSOL capped the price of CNX stock and hamstrung the special committee.